Hey guys, thanks for joining me. I wanted to jump on and make a quick video because we have a huge decision coming out of a federal district court in Oregon where a judge actually appointed by Donald Trump has just issued a temporary restraining order blocking Trump from federalizing the Oregon National Guard for deployment into Portland. So I'm going to explain to you why this is such a big deal, what the legal standard was, what the evidence showed, and what it means going forward. As briefly as possible, we're going to look at some of the highlighted portions of this opinion that I think are important. Now, the reason this is really a big deal, I think, is two reasons. Number one, there is a process for federalizing the National Guard for deployment into the cities of this country. We saw Donald Trump do that with respect to Los Angeles, as an example. Washington, D.C. is different. It's a different process because that's federal property. And you basically have to federalize the National Guard under 10 U.S.C. 12406. Then they're deployed into the city. Now, in the case that just came out of LA about a month and a half ago, finding that there was a violation of a federal law known as the Posse Comitatus Act, that happened after they'd been federalized, and it was about their operational behavior that the decision was based upon. This is earlier at the very beginning, and the court blocking Trump from even trying to even grant power or obtain authority over these troops to put them into the city of Portland. That's the first reason. Secondly, it's a TRO, and TROs are hard to get. I've obtained many of them, but I've also had many cases where I had great facts, but wasn't able to get that relief. And the reason why is it's considered an extraordinary remedy under Rule 65 of the Federal Rules of Civil Procedure. And it's extraordinary because it's happening before a trial at the very outset. The way it works is if you need emergency relief, you file for a temporary restraining order. If granted, that lasts 14 days. And then you have a preliminary injunction process. And if that's granted, that lasts throughout the litigation until trial. So we're at the very beginning. You haven't been able to present evidence, and the defense hasn't been able to provide its defenses and its evidence in the normal course of things and then have a trial. You're at the very beginning, and you're asking a lot of the court. That's how it's seen in the law. Obviously, makes sense. Now, let's get to what the court found. I think first and foremost, we need to understand, the gravity of this situation, and I think the courts are starting to get it. This case involves the intersection of three of the most fundamental principles in our constitutional democracy. The first concerns the relationship between the federal government and the states. The second concerns the relationship between the United States Armed Forces and domestic law enforcement. And the third concerns the proper role of the judicial branch in ensuring that the executive branch complies with the laws and limitations imposed by the legislative branch. Key sentence here. Whether we choose to follow what the Constitution mandates with respect to these three relationships goes to the heart of what it means to live under the rule of law in the United States. All right, so what are the key relevant facts here? Well, we'll get to what the law, basically requires and what Trump was unable to show. But what you need to understand is that, Trump has tried to justify, his effort to put troops into Portland by, that the protests are out of control. But in fact, what the evidence showed is that the peak of the protest period against ICE was actually back in the summer, June and July. And that going forward, and especially in September, the intensity of those protests has gone way down. In addition to that, there's been very little lawless, breaking any laws being broken whatsoever, and actually much less than what was happening in Los Angeles. And so what you have here is a situation where things are relatively peaceful and key. They're being handled well, and there's more than enough local police presence to take care of it. So we'll understand why that's relevant here in a minute, but that's the timeline you need to understand. Now, when we get to, the court goes through the process of, basically the facts, what happened. And then we see here, this is on page 6. The court talks about, under subsection B, the law enforcement resources in Portland. I'm not going to bore you with all the acronyms and all the different things that happened, but basically there was a lot of evidence presented for the for the temporary restraining order stage. I mean, sometimes you can file a temporary restraining order and try to get a court hearing in 2 to 3 hours. So the fact this happened very quickly, and the state was ready, and the state of Oregon and the city of Portland, both of whom were plaintiffs against the Trump administration and the agencies acting underneath him, is impressive. But what the point of this section here is the court went through the evidence and found there's more than adequate local resources to handle the situation, and the situation is well under control. That's the key issue. Okay, and then it goes through the defendant's actions relating to the federalization of the National Guard. This is less important, except for it kind of details how on June 7th, 2025, Trump issued this broad memorandum basically finding that anytime that the Secretary of Defense, and I'm going to call it that, I'm not going to call it the Secretary of War because I think that's ridiculous and it's not actually the correct legal statutory term, that basically he could federalize the National Guard anywhere he wanted, basically at a whim. It was unlimited in time and scope. And that's key here because it shows that there's this unfettered design and plan to put troops in cities all across this country. And of course, only ones that voted Democrat and have Democratic leadership in Democratic states. Okay, let's get to the statutory framework. This is what Trump had to show, all right? So, and I think this is really key to understand. So 10 U.S.C. 12406 is a statute that allows the president, if certain criteria are met, to federalize the National Guard in every state and basically turn them into federal troops to put them in the cities. And what you have to show for that is that basically it's one of three things, okay? And this is on the second page where it has sections 1, 2, and 3. The United States or any of its commonwealths or possessions is invaded or in danger of invasion by a foreign nation. Well, we don't have that. 2, there's a rebellion or danger of rebellion against the authority of the government of the United States. Or 3rd, the president is unable with regular forces to execute the laws of the United States. We're dealing with sections 2 and 3 here. Basically, what you have to show is that there is, ongoing violent situation that is out of control and can't be handled without the use of these troops. That it is an extreme situation, it's emergency, and it has to happen. One thing I really think people need to understand, you look at the top of page 17, there's this thing called the Militia Act, and the militia, there's a clause in the Constitution. It's actually Congress that was given the authority, and I didn't know this until I'd done some prior research with respect to the situation of the case in LA, that Congress has the authority to call up and nationalize the federal guard in order to put down a rebellion. And it's not the president as commander-in-chief. I think a lot of people don't understand that dichotomy, that when it comes to this situation, it comes to the military, the Constitution gave that authority to Congress and not the president. So, and it's under that authority that they passed this statute that we're analyzing now, 12406. All right. So then it goes through the analysis of whether or not the president is able to meet the threshold and show that either of the two subsections of 406 are met, 12406 are met. Now, obviously, the plaintiff has the burden of proof, but the plaintiff presented a lot of evidence showing that, and then it's basically the president has to show, in response to what the plaintiff's presented, that the statutory criteria are met. And it only has to meet one of the three. Now, again, the court assesses whether the president invoked 12406.3 based on a colorable assessment of the facts and as they existed at the time that he federalized the National Guard. Key first point here. He tried to talk about prior violence, prior issues that happened before, September. That's irrelevant, the court says. It's, do the conditions on the ground warrant federalizing the National Guard when you did it? Doesn't matter what happened in the past, okay? Now, when you go through this, the court says, look at the top of the page. In this case, and unlike in Newsom 2, plaintiffs provide substantial evidence that the protests at the Portland ICE facility were not significantly more violent or disruptive than the days or even weeks leading up to the president's directive on September 27, 2025. The record evidence establishes that while disruption outside the Portland ICE facility peaked in June of 2025, federal and local law enforcement officers were able to quell the disorder. That's key. Like I said, the intensity of those protests have been going down. And when they went down is when he federalized the National Guard in that order on September 27th. Again, therefore showing there's no reason to actually do it. Now, it goes through some of the things that happened. I mean, these are just pathetic, stupid things like shining a flashlight in the eyes of an ICE agent, or getting in the way of a vehicle once. I mean, these are not the things that justify the extreme situation of putting federalized National Guard troops into an American city. And again, Trump administration typically with their attorneys making stupid arguments here. Just wanted to point this out. In support of their opposition, defendants, the Trump administration, and those under him rely on the occurrences of violence elsewhere in the country and the risk that peaceful protest in Portland might escalate into violence, quote, at any moment. Again, that's ridiculous. It's what's happening in Portland that matters. Finally, the court says, listen, although the president is entitled to a great deal of deference, he has to show that he is unable to, with regular forces, to execute the laws of the United States. And that does not mean, just because we're giving you deference, that we have to just ignore the facts and what's actually happening. Then it goes to this other section. Okay, he can't show that. Can he show there's a danger of rebellion? And the definition the court relied upon is the rebellion must not only be violent, but also be armed. Second, a rebellion must be organized. Third, a rebellion must be open and avowed. Fourth, a rebellion must be against the government as a whole, often with the aim of overthrowing it, rather than opposition to a single law or issue. Well, we don't have that here, okay? This is not about overthrowing the government or against Trump, except with respect to his immigration policies, which, are wildly illegal. And they have been from the start. Whether it's sending people to CCOT in El Salvador, sending people to Sudan without any due process, on and on and on. We see it every single day. Outrageous events like what happened in Chicago. And that's what people are mad about. And that does not constitute a rebellion to just, protest against that one issue. Again, when you look at what's happening in Portland, the court finds that under this section as well, it doesn't meet the standard. The protests in Portland were not a rebellion and did not pose a danger of rebellion, especially in the days and weeks leading up to the federalization. And as discussed above, although defendants presented evidence of sporadic violence against federal officers and property damage to a federal building, they have not shown, any evidence demonstrating those episodes of violence were part of an organized attempt to overthrow the government as a whole. And therefore, defendants have failed to show the president has a culpable basis to conclude that Section 12406(2) was satisfied. That's key for another reason. Not only did he meet the statute, but you've got Stephen Miller and all these nut jobs in the Trump administration going out there and saying, oh, Antifa and George Soros, it's all organized. They're working together. This is a form of extremist organization of terrorism. And what the court actually found, again, this always happens with the court. You take Stephen Miller's, crazy statements, the extremeness of those, and then you actually compare what they can prove in court. They're always totally different. He says some wild, crazy stuff, and then what he can actually prove is basically nothing supporting that. Same thing here. Okay, so what are the claims for relief? Not only 12406, that he didn't comply with that, but also the 10th Amendment. So there's two claims. And the court found Oregon and the city of Portland had actually proven their elements under the TRO standard as to those two claims and didn't even have to address the other ones. So they could have, prevailed on those other ones too. But instead, she looked at the first two and said, look, you guys have such a strong case here for a TRO, and you're so likely to succeed on the merits, even on these first two, I'm not even going to look at the other ones. So this is a powerful decision. And what the 10th Amendment basically says is that it's sort of circular in its logic, not because the judge did anything wrong, it's just the way these claims work. But basically that the 10th Amendment says that any powers that the federal government doesn't have or the president doesn't have are reserved to the states. And because he was acting in excess of his constitutional authority under 12406, he's violating the 10th Amendment and with respect to the process of the federalist system that we have, where we have delegated authority between the state and federal government. Okay, that's sort of what it means there. I mean, not sort of, that is what it means. Now, because the president is federalizing the Oregon National Guard, absent constitutional authority, his actions undermine the sovereign interest of Oregon as protected by the 10th Amendment. Oregon has a 10th Amendment power to control its National Guard to the extent it is not cabined by the militia clause in the federal U.S. Constitution. And as discussed above, defendants have acted outside the scope of his constitutional authority conferred by Congress. Put another way, defendants have interfered with the constitutional balance of power between the federal and state governments by federalizing the state National Guardsmen for federal service without statutory or constitutional authority permitted by their federalization. Okay, what that all means is a lot of jargon, is that in this situation, if you can prove a 12406 claim, then you basically are going to be able to prove a 10th Amendment claim as well. They're basically tied together. Irreparable harm, again, not as important of an element here, I think, in this situation. What's more important are, again, likelihood of success on the merits. Then secondly, let's get to the really eloquent, powerful, moving part of this decision. And that is whether it balances the equities between the parties and it's in the public interest. Okay. So when you're getting a TRO, the court says, okay, you've proven you're likely to win at trial. You've proven you're likely to have irreparable harm. But is it in the public interest to grant, what you're asking for, to give you this emergency relief right now, right at the beginning of the case, before anybody's been able to really litigate things and show what the evidence might be at trial with the crucible of litigation? And is it more fair to you or more fair to your opponent? And they sort of balance all these things together. And here's what the court said. This country has a long-standing and foundational tradition of resistance to the government overreach, especially in the form of military intrusion into civil affairs. That tradition has deep roots in our history and found early expression, for example, in the constitutional provisions for civilian control of the military. And then it goes, this is a case from 1972. And then it talks about James Madison's address to the Constitutional Convention in 1787, where he said, a standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have always been the instruments of tyranny at home. The historical tradition boils down to a simple proposition. This is a nation of constitutional law, not martial law. Defendants have made a range of arguments that, if accepted, risk blurring the line between civil and military federal power to the detriment of this nation. So that, I think, is accurate, and it's a key point here. In this court's exercise of its authority, we see a runaway train, and I'm glad to see a federal judge, even when appointed by Trump, doing the right thing here and granting this temporary restraining order at the very earliest possible stage that it could do so. And so, what does this mean going forward? Well, it means that Trump can try to appeal this, but if he actually tries to send the National Guard into Portland, he's in contempt of court. He's in violation of a court order. And, he's probably going to appeal to, I believe this will be in the Ninth Circuit, which is, one level below. That'll be heard, and then he can go to the U.S. Supreme Court. Now, technically, I'm not sure that the grant of a temporary restraining order is actually a final appealable order. He may have to wait, as a procedural matter, until there's a preliminary injunction issued, which will be in 14 days. So that's a legal question. Not all orders are actually appealable. They have to wait till it's ripe, and there's a situation that's developed enough to actually kick it up to those higher courts. So, but that's where we're at. Again, not only does it control Trump, it also controls the state National Guard, because this decision, whether or not the National Guard is a party, the state of Oregon was a plaintiff, and therefore it would be a violation of the National Guard's commanding officers to listen to Trump and actually show up in Portland. So all around, nothing should happen for the next few weeks. We'll see how this litigates further. Oregon's got a strong case. I'm glad a judge is putting her foot down so quickly and doing the right thing. And I think the key thing to understand is they see what a grave situation we're in this country. You better get your mind around that too. So, all right, guys, thanks for watching. Keep it here for more updates. Love you. Have a great weekend.